So sorry about that. My phone died. We were right here at the section where the judge said that we violated the custody order, had a history of violating the order that he just made, that I have a history of not cooperating with the other parent or party in parenting, which is an obvious lie because we hired the attorney to draft up a parenting plan. And then he ordered that not to move or travel, and this is ex post facto, after the fact that we are in Utah already by this date. And the twins' mother had known this fact. And then on May 3rd, 2024, Judge David M. Sanders directed the twins' mother to go to the DA to enforce the order, which is highly odd. Why would you tell them to go to the DA to enforce the order instead of sending the order to the other person to give them an opportunity to abide by the order? Plus, it's not effective until the order is served. And then the DA investigator Lance Williams in report number 1 and the DA case number made the false and misleading statement and admissions of violation of utilization of police resources to apprehend and seize my daughters and my person without a warrant. So the whole thing about this warrant is that I had when I was arrested by the Marshals, they did not produce it upon request. Nobody had a copy of it. I had two private attorneys, one in Utah, one in California, requesting copies of this warrant, and it wasn't produced for about 19 days until I was in California. When I finally got to the jail, the CO, Cooper was his name. He couldn't book me in without the warrant, and it wasn't in the system. And this is 19 days later. And the other thing about the warrant is that it's a Remy warrant. So they're holding me without charges for 19 days. They didn't come up with charges, and I was arrested on May 4th. They didn't come up with charges until May 22nd is when they finally came up with charges of me violating a custody decree. So that's the story behind the warrant. Also, there wasn't any probable cause on the probable cause affidavit. When I was finally transported from Utah, they hired a private transport company. And the thing about warrants is that a private person cannot enforce a warrant. So there's another red flag there, a violation that they did. And then I had protested the warrant that there was no probable cause affidavit because all they had was a cover sheet. There was another red flag about the warrant is that it's signed twice by the judge, which shows me why would it be signed twice? Most warrants are only signed once. So there's just a lot of fudging of the paperwork. I would like to get a forensic digital audit of how this warrant was signed by the judge, digital signature, so there should be email and digital tracing of how this warrant was put together. The other thing is, what was the other thing? So my person without a warrant. Oh, so when I got to the jail, the warrant wasn't in the system. The CO couldn't book me in. he had to have it faxed over. And then that's when I finally got a copy of the warrant. And the copy that I have has the fax number showing that it was faxed. If it was truly in the system, there would be no need for them to fax it. So that's the other thing. And then nor a copy of an executed and served court order. So they didn't have an executed and served court order. Mr. Williams later testified not investigating, to not having a copy of the court order, and not contacting me. Mr. Williams did gain access to my cell phone location without a warrant, though an invalid warrant was digitally signed without an affidavit attached and issued after the fact. So AT&T gave him access to my cell phone without having a warrant. On May 3rd, the DA investigator, Michael Stone, between 6:30 and 8:09, authored the Remy warrant without an affidavit digitally signed by Judge Sanders, and entered into the warrant system before 8:28 as a penal code section 278.5, a violation of a custody decree. They said my race was American Indian, and they approved night service. The warrant was only effective for my address, and there is no probable cause, as a violation would be ex post facto, and the ex parte temporary emergency order is not only invalid and void as to process, but not effective until served. On May 3rd, 2024 at 8:28, they attempted to serve it at the address. Which again, I say it's odd that it says that it was entered into the system, but the CO couldn't pull it up to book me in. On May 3rd at 8:40 to 8:50, during the daily phone visits with my twin daughters and their mother, she told me she got a custody order. I told her to text it to me. She said she could not because she did not have a copy. Okay? She wouldn't text me the order. If you have an order, text it to me, prove it to me. On May 3rd, 2024, at 9:21, Investigator Williams, Stone, Trace Durham, and Sergeant Belshie interviewed the twins' mother. All three investigators give the false and misleading statement of having copy of the ex parte order within their reports, as well as Stone and Durham stating that each of them sent a copy of the ex parte order and Remy warrant to Summit County Sheriff's, Utah, after the interview. After the interview, Williams and Trace later testify they had no such copy at the preliminary hearing. So we have transcripts of that. The other thing about the U.S. Marshals Task Force is they're also known as the Murder Squad in Utah by the locals, because they have killed people before me and they have killed people after me. So what this felt like when they were doing this, it felt like a hit job. Stone's report is based on information from Williams and victim advocate Aherd. On May 4th, 2024 at 2 a.m., Summit County Sheriff Sergeant Tilbot, after receiving the false and misleading information, spoke with his administration and either requested assistance or gave the investigation to the United States Marshals, depending on Stone, Durham's, or Williams' report. So each one is different. you don't really know how by what each one said. On May 4th, 2024 at 7:30 a.m., U.S. Marshals contacted Stone stating they were putting together a team. Okay, so the thing about this VFAST team is that it is a violent, it stands for violent fugitive apprehension team. Okay? So, for one, this is not a violent charge. And number two, I was not a fugitive. Okay? I was legally and lawfully within Utah. Williams' report states a task force with U.S. Marshal Manuel Scott sending Form USM 560, Delegation of Apprehension Responsibility and Case Referral, which Stone signed and returned. This delegation of power to arrest at Valley Springs, California, has no force or effect beyond the residents, especially outside California in the state of Utah. On May 4th, 2024, at 11:55, after playing at the park with my twin daughters, who are 3 years old, my niece, who is 11, my nephew, who is 10, and my sister, we began to walk home. As I was walking with my daughters, one in each hand, we were tackled from behind by a man in plain clothes. Okay? Then, my sister was slammed against an incoming vehicle and then slammed against the pavement. She told my 11-year-old niece to start recording. The marshals grabbed my 11-year-old niece, picked her up into the air, and slammed her to the pavement. And she screams out. She had nightmares about the men coming in and getting her. My nephew, he's got autism and non-verbal autism, and then they put bruises all over him, grabbing on him. Sorry about that. Okay, and then, well, let's look at that report. So my sister, she ended up filing a complaint with the marshals. Since I've been out, I filed a supplementary complaint with the marshals. I filed a complaint with Summit County. I filed a complaint against Calaveras County. And because they're charging me, I filed a complaint with the Inspector General against the U.S. Attorney. But this is my sister's complaint. Let's look at the pictures of the bruises on my niece from being slammed to the ground by a grown man. Like, I can't believe that. It's disgusting. Okay. So let's go over the clearly established law. This is a typo right here. It's supposed to be 278.5, but according to 278.7, 278.5 is not applicable for 10 days. I reported to social services both Part A and B the same day, and she has a mandatory reporting requirement. And then I reported it to the attorney, who also has a mandatory reporting requirement. And then I was arrested within 6 days. So this law isn't even applicable yet. and they sent the marshals after me. And then under Raymond v. Vasquez, in this 14 USC section 1983 action, the denial of absolute immunity was proper because providing false information and failing to give notice were not prosecutorial. 2, the denial of qualified immunity was proper because there was a clear due process to notice and judicial deception was clearly unlawful. So what I like about this case is that you can actually utilize it for any case where the government has lied, and it's clearly established law, which is what you need in order to prove a constitutional violation. An individual has a well-established constitutional right to be free from deception in the presentation of evidence. In the case for that, a seizure conducted pursuant to a warrant obtained by judicial deception violates the Fourth Amendment. Deliberately fabricating evidence in civil child proceedings violates the Due Process Clause of the 14th Amendment when a liberty or property interest is at stake. Government perjury and the knowing use of false evidence are absolutely and obviously irreconcilable with the 14th Amendment's guarantee to due process in the courts. There are no circumstances in a proceeding that would permit government officials to bear false witness against a parent. A claim of a parent's whereabouts are unknown is foreclosed by the decision in Hardwick. In that case, we observe that general statements of the law are not inherently incapable of giving fair and clear warning, and in some instances, a general constitutional rule already identified in the decisional law may apply with obvious clarity to the specific conduct in question, even though the very action in question has not been held unlawful. The salient question is whether the state of the law at the time of their misconduct gave fair warning that their misconduct was unconstitutional. Here, a reasonable person in their shoes would have understood, based on prior decisional law, that providing incomplete and false information to the court to convince the court they had satisfied the due process notice requirements or any other requirements. So the reason why they're in brackets is because I'm taking the names out of the people in that case and I'm just inserting a general word. That's why I put any other requirements. Constitutes judicial deception. Long before September 2018, it was clear that there are no circumstances in a proceeding that would permit government officials to bear false witness against a parent or anyone. You're not allowed to lie when you work in government. Observing that the right to be free from judicial deception in child custody matters or any matter was clearly established prior to 2016. That anyone has failed to identify a case that specifically evaluates the very action in question does not change the analysis. It is obvious that the prohibition against bearing false witness applies to representation that everyone made about a parent's whereabouts, or competency, or vexatious filing, or anything else. So these are the other cases that I have to deal with. Especially when those representations will determine whether a juvenile court will proceed with a hearing to remove a child from that parent's custody without hearing from the parent first. The fact that the right to be free from judicial deception arises in part under the Fourth Amendment also does not save anyone's immunity defense. While it is true that specificity in past decisional law is especially important in Fourth Amendment contexts where law enforcement officers often have to make quick decisions with significant consequences. That principle more appropriately applies in excessive force cases arising under the Fourth Amendment. Ex post facto clause. The Constitution prohibits both federal and state governments from enacting any ex post facto law. The phrase ex post facto was a term of art with an established meaning at the time of the framing. Any state or case law or common law which punishes as a crime an act previously committed, which was innocent when done, which makes more burdensome the punishment for a crime after its commission, or which deprives one charged with a crime of any defense available according to law at the time when the act was committed, is prohibited as ex post facto. Two critical elements must be present for a case or common law to be ex post facto. It must be retrospective, that is, it must apply to events occurring before its enactment or rendering, and it must disadvantage the offender affected by it. Warrants and warrantless arrests, invalid warrant and dishonest probable cause and punishment, color of law. In determining the sufficiency of an affidavit for issuance of a warrant, the test of probable cause is approximately the same as that applicable to an arrest without a warrant. So this test has to be the same as if they didn't have a warrant. Thus, the fundamental constitutional requirement for the issuance of a warrant for the arrest of a person is probable cause. That is a state of facts, as would lead a person of ordinary care and prudence to believe and conscientiously entertain an honest and strong suspicion that another person is guilty of a crime. All the cases for that. When a defendant challenges the validity of an arrest warrant, the burden is on the prosecution to establish its legality. So they actually took that out of our transcripts, and I just emailed the attorney and he confirmed it. I asked him, I told him that I noticed that they took my facial challenge of the warrant out of the transcripts, and I asked him, why do you think that is? And he answered with, I don't know. So he just admitted, we have a record now, that they took my facial challenge out of the transcripts. Now, this judge has just been publicly reprimanded by the Judicial Council. His name is Timothy Healy out of California. Look up the Judicial Council. It's a 29-page report. And when you read that report, it sounds exactly what happened to me. My sister's foster mother, she asked, is this your guys' case? And she said, no, this is already what's happened. So even while they were investigating this judge, he was still doing the same thing. All right. Okay, the burden is on the prosecution to establish its legality. The case law permitting a defendant to attack a facially sufficient search warrant affidavit on the grounds that it contains misstatements or omissions is equally applicable to arrest warrant affidavits. If an arrest warrant, that was the one thing so I said I wanted to do a facial challenge on the warrant, and the judge said, I'm not ready for this. You know why he wasn't ready for it? Is because, remember, it wasn't in the system yet. He couldn't even pull it up. If an arrest warrant is based solely upon a complaint or affidavit framed in terms of information and belief rather than upon the affiant's personal knowledge, or solely upon a complaint that is phrased in statutory language, the warrant may be constitutionally inadequate if sufficient allegations of probable cause are not otherwise present. So when they're putting their complaint together and they're just using statutory language and they issue out a warrant, it says right here that's constitutionally inadequate. And I'm pretty sure all these judges and all these DAs across the country are doing this. If the arrested person requests the warrant be shown, it must be shown to him or her as soon as practicable. So when I demanded it, it was under the penal code that they had to produce it. They didn't do that for 19 days. Although a police officer may make an arrest based on information received through official channels, the prosecution must show that the officer who originally furnished the information had probable cause to believe that the suspect committed a felony. And all the cases that back that up. Justifying an arrest based on information received by an officer through official channels requires the prosecution to trace the information received by the arresting officer back to its source and prove that the originating or transmitting officer had the requisite. Sorry, I have trouble pronouncing those type of words I have a plate in my face, so sometimes I have trouble pronouncing that word. Probable cause or reasonable suspicion to justify the arrest or detention. It is not the case that the courts must look only to the perceptions of the officer in the field, rather than trace his or her probable cause determination to its source in the law enforcement system. Instead, where police communication is the source of the information assuredly constituting cause to detain, the court must look to the transmitting officer and determine whether that officer had information constituting probable cause or reasonable suspicion. Probable cause for a search or an arrest without a warrant may be proven by information passed from one officer to another if it is shown the information was factual rather than conclusionary, related specifically and articulable facts, was the product of personal observation by the informing officer, and was reliable. The issue boils down to whether the latter officer's reliance on information was reasonable. The people must prove that the source of information is something other than the imagination of the officer. The general rule is that where law enforcement authorities are cooperating in an investigation, the knowledge of one is presumed shared by all. A peace officer may arrest an individual in any county, even though he or she has no jurisdiction, if such an arrest could have been made by a private person without a warrant. Thus, an officer's power of arrest, when acting beyond the limits of the geographic unit by which he or she is appointed, becomes that conferred on private citizens in the same circumstance. Now back to the Marshals. They were delegated an authority. They became California officers, and they are exercising powers beyond the territory, and they became private persons. Okay? A private person may not make an arrest under a warrant, so they can't arrest me saying that they had a warrant. Not permitted. When a police officer makes an arrest without a warrant, the arrest must be made at the time of the offense or within a reasonable time thereafter. If the arrest is not made contemporaneously with the commission of the offense, the statutory basis for the arrest has evaporated. They're arresting me for me leaving on the 28th. That's what they arrested me for. That's what I was being tried for. Thus, in making an arrest without a warrant, the arresting officer must act promptly, as soon as possible under the circumstances, and before he or she transacts other business. So let's kind of go back. She called 911 and they told her that it was a civil matter. So the cause evaporated once that dispatch said this is a civil matter. And then they convoluted everything by mixing civil and criminal, because the actual warrant that they can issue is a family law civil warrant to obtain custody of the children. They didn't have jurisdiction to arrest me. A temporary detention may not be justified after the fact on a basis not relied on by the officer at the time of the detention. So this is because after my first appearance, I filed the notice of appeal, and because I filed the notice of appeal, according to a case Smith versus Smith, they didn't have the power to prosecute me anymore. And then the judge changed the fact relied upon to I had a malicious intent because of statements that she said that I said. She said that I said, you can have the kids over my dead body. I never said that, but even if it was said, I don't think that you can try somebody for saying that, because it's protected speech. Especially since that saying could have multiple different definitions behind it. It could be like, if like me, it would be, I will fight for my children in the court, because everything I do is court related. I'm too old to be fighting with people. This is why it's so absurd that these marshals are saying that I resisted or I assaulted them. It's completely absurd. The fact, okay, such a rule would countenance a detain now, justify later approach to police instructions that is contrary to the constitutional requirements that protect a citizen against unreasonable searches and seizures. So when they're arresting you on one thing and they're trying to try you on another, trying to justify the reason why they're detaining you, it's unconstitutional according to this case. U.S. Constitution Amendment 4, the Supreme Court has recognized that a search or seizure pursuant to an invalid warrant constitutes an invasion of the constitutional rights of the subject of that search or seizure at the time of the governmental intrusion. The wrong condemned by the Fourth Amendment is fully accomplished by the unlawful search or seizure itself. Even when only a portion of the search warrant is invalid, the subject suffers a constitutional violation. A blank, that is a warrant that is issued upon probable cause is invalid. Blank. Oh, the warrant that is not issued upon probable cause is invalid. Additionally, prior cases have rejected claims for qualified immunity where an officer has sought a warrant knowing there was no probable cause to support it, or intentionally misrepresented the facts in order to procure a warrant. No reasonable officer could believe that it is constitutional to act dishonestly or recklessly with regard to the basis for probable cause in seeking a warrant. A plaintiff must make 1, a substantial showing of deliberate falsehood or reckless disregard for the truth, and 2, establish that but for the dishonesty, the challenged action would not have occurred. If a plaintiff satisfies these requirements, the matter should go to trial. Materiality is for the court. State of mind is for the jury. Every public officer or person pretending to be a public officer who every public officer or person pretending to be a public officer who, under pretense or color of any process or other legal authority, arrests any person or detains that person against his or her will without a regular process or other lawful authority is guilty of a misdemeanor. So them arresting me without a valid warrant is a misdemeanor. Excessive force. The United States Supreme Court laid out a 2-part analysis for determining an officer's entitlement to qualified immunity. First, as a threshold matter, the court must decide whether, taken in light most favorable to the party asserting the injury, do the facts alleged show the officer's conduct violated a constitutional right. If the plaintiff alleges conduct that would violate a constitutional right, Saussures' second prong requires the court to determine whether the right was clearly established in light of the specific context of the case, such that it would be clear to a reasonable officer that his conduct was unlawful in the situation he confronted. Quoting Saussure. First prong. Claims of excessive force are analyzed under the 14th Amendment's objective reasonable and 4th Amendment's jurisprudence that has long recognized that the right to make an arrest necessarily carries with it the right to use some degree of physical coercion or threat of coercion to effect it. The ultimate reasonableness inquiry in an excessive force case is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting him, without regard to the underlying intent or motivations. To determine whether the force used was reasonable under the circumstances, court must balance the nature and quality of the intrusion on the individual's Fourth Amendment interests against the countervailing governmental interests at stake. In performing this calculus, the court must assess the quantum of force used and the measure of the governmental interests at stake by considering 1, the severity of the crime at issue, 2, whether the suspect poses an immediate threat to the safety of officers or others, and 3, whether he is actively resisting arrest or attempting to evade arrest by flight. Throughout, courts must use the perspective of a reasonable officer on the scene rather than the 20/20 vision of hindsight, and must make allowances for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a given situation. So again, that goes to a reasonable officer. It doesn't really matter what the actual officer is thinking in his mind, especially if he's being unreasonable, tackling someone from behind, not announcing that they're under arrest, them having their children in their arms, them playing at the park, knowingly unarmed, okay, not actively resisting arrest, not fleeing anything, okay, and then slamming and injuring children, stepping on children, stepping on my daughters. I just can't believe that they would do that. Like, the whole point of them coming was to protect my babies, and they're sitting there stepping all over them. And I have that image burned in my brain of my babies crying and me not being able to do anything about it. For a constitutional right to be clearly established, its contours must be sufficiently clear that a reasonable officer would understand that what he is doing violates that right. That's not to say that an official action is protected by qualified immunity unless the very action in question has previously been held unlawful, but it is to say that in the light of pre-existing law, the unlawfulness must be apparent. However, to find that a law is clearly established, the court need not point to a case with identical or even materially similar facts. Instead, the court must determine whether the pre-existing law provided the defendants with fair warning that their conduct was unlawful. Whether the right is clearly established is judged as of the date of the alleged incident and is a pure question of law. However, where the reasonableness of the officer's belief that his conduct was unlawful depends on the resolution of disputed issues of fact, summary judgment is not appropriate. Stating that whether the law is clearly established is a question of law for the court, but whether a reasonable officer could have believed the action taken was lawful is a mixed question of law and fact. Any genuine issues of material fact concerning the underlying historical facts of what the officer knew or what he did are questions of fact for the jury. For clearly established use of gratuitous and violent excessive force, see these cases, courts do consider whether officers gave fair warning before employing the force as a factor in the excessive force analysis. Officers giving no warning and gang tackling a person could reasonably be considered provocative and done in bad faith, as well as the use of hobble restraints as excessive force. In Robinson versus Solano County, an en banc decision, so full panel court, the Ninth Circuit clearly established that pointing a firearm at an unarmed suspect's head who poses no immediate risk to the safety of the officers or others is a use of excessive force. So what happened was that while I was in handcuffs, they were pointing the taser in my face, telling me that if I effing move, they're gonna tase me in the face. They did that twice, and it was unnecessary to even make the statement and point the taser at my face, because I was not actively resisting. I answered these officers with "Yes, sir." I yelled it out so that everyone who was around, all the pedestrians that were around, they could hear me. In so holding, the court stated that the development of the law with respect to arrests and decisions now allows us to recognize as a general principle that pointing a gun to the head of an apparently unarmed suspect during an investigation can be a violation of the Fourth Amendment, especially where the individual poses no particular danger. Stating that since 1984, pointing a gun at a suspect's head can constitute excessive force in the Ninth Circuit. And misdemeanors are cite and release. In general, the statutory cite and release procedure for misdemeanor arrest is mandatory in California. And then conclusion. Under the American philosophy of government, the child is not the creature of the state, and where the father, as he has a right to do in this case, determine to domicile his children in the state of Utah, it does not lie within the power of any court of this state to send him to jail for doing that which he was legally and lawfully entitled to do, nor to require him to go outside the state to undo such lawful act. In re-application of Chandler, and that was for a petition for writ of habeas corpus, and it was granted. Petitioner was discharged from custody. And then, so this is what I put into the Ninth Circuit. All right, so I'm gonna wrap this up, and I want to thank everybody for watching the video. And this is what I went through for the last 90 days, and now I'm having to go through still defending myself against these heathens, disgusting men that will slam children and abuse little babies. My babies are only 3 years old. Okay, they're only 3 years old. See? They're just little children. They didn't deserve that. They're just tiny little things. Precious little angels. Little angels being tackled by grown men. So, if you're watching this, please share it. Help get the word out. The United States Marshals did to these precious little babies. Alright. Thanks for watching. Bye.